Here in this court, we ask for your Holy Spirit to be with us tonight, proceedings in this. We ask that your will be done in all things. You can be guided and directed in all that we do and all that we say here today. For this we pray in your name. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Honor the Texas flag. I pledge allegiance to thee, Texas, one state under God, one and indivisible. Agenda item number 3, public comment. Okay, our first public comment will come from Mr. King.
So just so the community knows, for one, the community knows that tomorrow I'll be replacing culvert in Bentwood, and that's on Bentwood Drive right next to Lakeview. The problem with this is I got to close that road for 2 to 3 hours to remove culvert, put a culvert back in just so it can be passed. So we will try and build a road just inside of it, and then we'll cut that road back out just so we can get passenger cars through that sand. But that'll be taking place tomorrow. Culvert's getting delivered today. I got to cut the road out.
Our second public speaker is Lee Google. He was on picture. Yeah, very much. Good morning. On the week of June 23rd, I called the Sheriff's Office due to a continued problem on County Road 319 between 775 and County Road 307. The problem has been escalating in occurrence and causing a very serious safety situation for all motorists. I called due to several vehicles being parked on the roadway on top of the hill at 319 and Golden Hills. Several persons were standing in the roadway by their vehicles with no regard for public safety and ample space for them to park safely off the roadway. As I drove around the vehicles, nothing directed traffic, and I was nearly hit head-on by a oncoming concrete truck topping the hill. Upon contacting the Sheriff's Office, I talked to Lieutenant Orr. As our conversation progressed, he advised me to call when I see these situations. After that, he no longer addressed my concerns and only stated that I should contact you as the county commissioners as to why I would not give them more deputies. It appeared as he blamed you, the commissioners, for the lack of deputies, even after I advised him that numerous law enforcement agencies report understaffing yet effectively functioning. He was very condescending as he advised me that he cannot staff the road 24/7, 365, and I assured him that's not what I was asking. But when I called to report an immediate safety concern, an active lawful violation, I would think the Sheriff's Office would take actions to respond and investigate. He stood fast on a statement for me to address you as commissioners, and it felt as if he implied that he were the reasons we as citizens are at risk due to their understanding. Then on June 27th, another situation where at dusk my wife and I were traveling east on 319 and a white dually unoccupied park with the front doors open, pulling landscape trailer was parked on the roadway on the downhill side facing the westbound lanes of eastbound traffic, head-on incoming traffic, with the headlights blinding as we topped and crested the hill. I called the Sheriff's Office to report the situation, and the deputy who responded seemed to know that the lieutenant was aggravated by that call, and he also advised me to contact you as the county commissioner to tell you to put up signs. I advised him that the signs were not needed, as the Texas Penal Code 4203 section of a highway or passageway clearly addresses the situation. It states a person commits an offense without legal privilege or authority to intentionally, knowingly, or recklessly obstruct the highway, sidewalks, railway, waterway, elevator, aisle, hallway entrance, or exit to a public or a substantial group of the public has access, or any other place used for the passage of persons, vehicles, or conveyances, regardless of the means of creating the obstruction. I offered suggestions of citations or even arrests being made, that is, the Class A misdemeanor in the state of Texas for a person to exhibit these actions as described above. The deputy then advised the other party that I was a detective, and for which department I worked for, and a constant caller. Due to the deputy making me say that person called the department to complain on me for harassing his employees who I videotaped actively committing the crime. I filed a complaint against that deputy for putting me and my family at serious risk for divulging such information, and to which I also advised to do so by my chain of command and the CLEAT, which stands for the Compliance Law Enforcement Attorney Association of Texas Attorneys. I reach out to you as directed by both the lieutenant and the deputy, and in doing so, it is my sincere hope that your assistance and oversight through budgetary and policy-making authority will ensure the Sheriff's Office, through due diligence, will use their resources and effectively fulfill said mandates to have the resources to do so. Thank you for your time and assistance.
pension awards and bond. We have a certificate of completion, Tax Assessor Collector Association of Texas, completing 2 hours of educational training, Don Barnett. Two certificates, vehicle titles and registration verification record for Ruby Camarillo and Danielle Northwest. Okay, all required new hire certificates for Lindsay McCullough, and she's very busy. There's many. They go into it. Agenda item number 5, approved bond of Brenda Trevino. Brenda Villa, you know her name. No. Commissioner, I'll entertain a motion.
Make a motion to approve the bond for Ms. Brenda Lee. Second.
Motion made by Commissioner King, seconded by Commissioner Curdo. Any other discussion regarding agenda item number 5? Hearing none, I'll call for the vote. All in favor say aye. Aye. All those against, nay. Ayes have it. Motion passes. We have agenda item number 6. Commissioner Martin, Precinct 1, open and read aloud the bids of Mariana Road Construction Project. Precinct 1 will do that at 10 o'clock. So somebody needs to remind me to get close to that and go bypass that. Go to agenda item number 7. We have Brenda Trevino, County Auditor, 7A, 1 o'clock. Budget workshop presentation discussion only on fiscal year 26 budget request by elected officials, and B, discuss and take action on fiscal year 26. That also will be at 1 o'clock. We will recess from this court and then reconvene at 1 o'clock for agenda item number 7. Agenda item number 8, we have Jason Collins, IT department, discuss and take action on migrating from the current on-premise telephone solution to a VoIP cloud system, including fax lines and analog devices.
Good morning, Commissioners.
Good morning.
This proposal will unify our current phone network into obviously one, and it will be in the cloud. It will save us approximately $10K a year annually, and it will get us off of some of the copper lines that we're currently using at the moment. So about a third of our network is actually still using the old traditional copper lines.
How does that work? You going to fiber optic or something?
Yeah, it's basically going to be cloud-based. Right now we're partially cloud-based. This will just go ahead and make it all. And it'll unify both of the phone systems between the Sheriff's Department and the county. Right now we have 2 servers that reside in different locations. And if you have to call the Sheriff's Department, you can't just dial an extension. You have to dial an outside line to get hold of them. So. Also, it'll cut back on the cost of the servers. They're deprecated. They need to be replaced probably this year, which would probably cost us close to $8 grand. Licensing and support for the servers, that would be about it. So I think the first year alone will probably save us close to 15 to 20 grand. But every year thereafter, approximately $10,000 savings. And you'll be able to fax from your desktop instead of having a fax machine or a printer. Currently we use just copper wire, so, you know, in the 70s. And we do have some gear downstairs that utilizes these copper wires, and those haven't been made in about 15 years. So if they go out, we're going to have a hard time replacing them. And whenever they do go down, we have to send out a specialist just to troubleshoot and support us. So there's extra cost there as well.
Is this something you can troubleshoot from
Yes, sir.
IT perspective?
I can troubleshoot it as well as there'll be a support in the contract. And there will be an app for the funds, just like you have right now with the ATS system. There won't be any phones replaced. You probably won't really notice a difference until it comes out. That would bring the
And we have enough phones to cover the ELC, right?
Yes, sir.
Okay.
Do we really need all the fax lines? I know the attorneys have to have them, I think, but I don't know about everybody else. I mean, it's just concerning because I don't know who gets the fax anymore.
Yes, sir. I have the same question. I'm still working on the answer to that. I would lean towards the answer being no. I think once we unify everything and digitize our faxing, we can cut back even more. I mean, we can all use just a few fax lines. So I think we have over 10 right now.
You got 21 listed on here.
21. I think they only did like 47 faxes in 1 month. And so we're paying quite a bit of money for that.
All right, Commissioner, we'll entertain a motion on agenda item number 8.
I'll make a motion on, migrating from the current on-premise telephone solutions to the VoIP cloud system, including whatever fax lines we may need, getting the rest of them off.
Second.
Motion made by Commissioner King, seconded by Commissioner Cardova. Do you have any other discussion regarding agenda item number 8?
Yes, sir. Length contract,
Yes, sir.
what's the length of the
Oh,
contract?
3 years.
It's a 3-year contract.
Sorry, I thought you were asking me to leave the contract.
No, no, and if we're not happy, the opt-out is what?
Or we got to wait 3 years. Not happy. You will be happier with this than what you have.
Okay.
Guarantee.
Without having the
As
rest
because the county's been very happy with it. They moved it there recently, a couple of months ago. They love it. I'm sure you like it.
So you're going to provide the service, we've got a 30-day or something. That's basically what it is. We always want an escape clause, in case we're not getting the service that we believe.
Excellent.
I have
Any other questions? Hearing none, I'll call for the vote. All in favor, say aye.
Aye.
All those against, nay. Ayes have it, motion passes. Thank you. We're coming up to you now. Agenda item number 9. Discuss and take action on mandated annual cybersecurity training requirements for all county employees, elected officials, and appointed officials who have access to local computer system or database and use of a computer to perform at least 25% of their duties to complete cybersecurity training that has been certified by the Texas Department of Info Resources, DIR. Course will be offered by TAC, and support tool participate.
And this one's just like last year's. I took the test a few days ago. Almost identical.
It's bad.
Yeah, I have to take it twice a year, actually.
Okay, so is this basically one we've had in the past that we all had to take? Every year? Yeah, okay.
Yeah, they just changed slightly. It costs approximately $5 per person. That's what we get charged.
Put that line on
It's September 15th. So don't worry, I'll be on everybody. Reminding them.
All right, Commissioners, I'm going to entertain a motion, whoever gets this is going to belong with me. So,
Well, I'll make a motion to approve the mandated annual cybersecurity training requirement through TAC.
okay, have a second?
Second.
A piece of reading all
I think you can abbreviate that.
Motion made by Commissioner Martin, second by Commissioner Cardova. We have another discussion regarding agenda item number 9. Hearing none, I'll call for the vote. All in favor say aye.
Aye.
All those against, nay. Ayes have it, motion passes. Thank you.
Thank you, sir.
Agenda item number 10, Commissioner Martin, precinct 1, discuss and take action on Wilson County Fire Marshal interview team.
We didn't finish this last time, so I'd like to figure out who's gonna be on this interview team and designate those folks. I said before, I'd like to see Commissioner Aiken on it, and I'd like to see Chief Thompson, and I saw, here he is, Chief, would you like to be on the interview team? Yes, sir.
I would recommend that we have all three chiefs on there.
Yeah, I mean, I got no problem with that.
If the other one will commit.
I've spoken with Chief Thompson this morning, and he will not be able to be on the interview team.
Did he give you?
He did. There's a conflict.
He's got a conflict.
The other two, fire chiefs have expressed their, interest in being on that panel.
Okay. How would you pose your motion?
Well, I mean, I don't know if, are you gonna sit in on those interviews?
So you should probably have
Sure.
5 or 4.
Yeah. Well, that's four.
4.
Yeah, oh yeah, and the sheriff.
Okay, that'd be 5.
That would be,
Who?
What about Bruce and Cindy, since they're gonna work directly with his individual?
I would have no problem with Mr. Otto on that. Do you have a problem with it?
no, I mean, and she said Cindy also.
Cindy. Okay, let's do it. We'll do that.
That's 7 people.
That's way more than enough.
Yeah, I wouldn't go any higher than that.
No. Okay, then I'll make a motion for, Chief Lopez, Chief Strelczyk, Commissioner Aiken, Jalen Bodiford, Jim Stewart, Sheriff, Cindy Stafford, and Liz Serrato to be on the interview team for the county fire marshal.
Motion made by Commissioner Martin, seconded by Commissioner King. Any other discussion regarding agenda item number 10?
If I may, you may
Yes.
want to clarify what you want the interview team to do, to interview and give them a choice to Commissioner's Court, narrow it down to 2 choices, which is clarifying what you want the team to do inside just the designation.
Why don't you just rescind and restate?
I'll rescind my motion. Well, yeah, I mean,
Let's have it.
I mean, I don't know, I'm fine with one, with a finalist and maybe an alternate in case something's wrong, you know, the finalist can't do it. I mean, sure, would you check the backgrounds of the top two candidates, or do you want to just do the first one, do them one at a time, or how would you do that, sir?
A background check is, check a week, a couple of weeks, a background check. I get 2, I don't know that I have to both of them in 2 weeks.
One at a time?
I could probably get that done. If you give 2, I got a background check done in 2 weeks. Depending on the extent of the background.
Well, you can, Mr. Goodhart.
We have to work for it.
Commissioner Martin, what is the motion now?
I make a motion for our interview team to be Chief Lopez, Chief Strelczyk, Commissioner Aiken, Jalen Bodiford, Sheriff Stewart, Cindy Stafford, Liz Serrato to bring to the court a primary and secondary candidate.
Still a second, sir? Motion made, Commissioner. First, motion rescinded, restated by Commissioner Martin, seconded by Commissioner King. Do you have any other discussion regarding agenda item number 10?
Yes. Most proper action for me is to abstain since I'm being named on it, or do I go ahead and vote?
Named off the,
On the committee.
that's okay.
Okay.
All in favor, say aye.
Aye.
All those against, nay. Ayes have it, motion passes. Agenda item number 11, we have Commissioner Martin, precinct 1. Discuss and take action on the Bushland County Fire Marshal proposed job description.
In the job description last time, there was no reference to having plan review capability. I believe Ms. Serrato has stated that that's one of the primary things that she needs assistance on. So if we're going to need that, then we need to amend the job description to include having plan review capability or the ability to obtain it within 90 days of employment.
It has to be an action item. I think this needs to be a discussion item, because with HR, we make this an action item, gentlemen, we have to bring it to court every time we change something in the job description. I think this is a discussion item. And HR does have the ability to change that as we see fit without bringing it back to court. So,
And there is one item on that job description that I have a problem with. Is there a residency requirement? They have to live, come on. They have like, if they don't live here and they end up getting picked, they got to be living in the county within 6 months.
There is a residency requirement. Within 6 months of the employment start date.
What if they live in the county of Oakland? Can't deputies go home every day with their vehicles go to the counties?
Is there any reason that couldn't be negotiated when we discuss that in regard? Because that may lead to the next item that's on the discussion.
I guess the question is it required of any other job title that we have in this spot?
We really don't. The only ones that it did potentially impact was deputies, because at one point, they had to live in the county, and then with all the people that was happening with San Antonio, with SAPD, and then everybody started going back to the right one county location or something. I mean, that's got a long history, but I looked at that myself. I mean, the main thing to me is that they know that this is a 24/7, 365 job. They need to be able to respond, and they got to respond in a reasonable period of time. If that becomes a problem, then they're not meeting the requirements of the job.
I'd be more comfortable with contiguous county, so that puts them in Wilson County or one of the surrounding counties. Still gives them to, in the event that they are needed to do their job after hours, they're within a strike zone that is responsible. Since it's being brought up.
So should we leave this up to HR to come up with that description and just go forward with it? I'm kind of in agreement with Commissioner King. We vote on this and we have to do it every time. So.
This will be
I
the
know
only
this is
job
what we
description
have.
that's ever been voted on.
Sorry?
This will be the only job description that's ever been voted on. But as far as plan review, under job duties and function, the last 4 bullet points on there all deal with plan review.
But it doesn't specifically say that they have to have the certification. Does it? The one that I got to.
You know, as far as certifications,
They have to be TCOL, and they had, I've got 2 others, and something else in the qualification section.
that is correct. And when I questioned Chief Thompson on the certification on that, he said it's a 60-day certification. That's why he did not include it in this job description.
Well, we want them to have it because that's the primary, going to be one of the primary functions that they have is to review plans and look at those things for the permitting department. So it needs to be in there. And yes, and I talked to Chief Tom, he said 60 days, I'd say 90 just because I think most places allow people 90 days to obtain a certification or something if they don't have it. So I don't see that as a, but it needs to be required because it's going to be part of their job. Because otherwise, we're going to wind up paying an outside company to do that and make it feasible.
Work for our firefighter commissioner.
And to me, outside looking in, the push has been trying to take and get someone to help with what's going on in our permitting department. The push has not been to get someone to be available to deal with people who are burning after hours illegally, whatever terminology is coming in place. This is all being driven by that office and her being backed up because there's a part that she's not able to achieve. And so, with that being said, the position doesn't really appear to be written that way. It is more of a emergency management type.
It encompasses all of it.
But we do need somebody to enforce these LD firms at night. Yes. Set these brush piles on fire in these subdivisions, go on and leave them unmanned. They promise us they'll have somebody there 24/7. When they burn these piles and they light them in the dark, they leave. We don't have anybody to enforce it.
That's the thing, this fire marshal is for the county, it's not for one specific area.
Right.
This is for the whole county, it's not for emergency management, permanent, sheriff's department. This is a fire marshal for the county of Wilson.
Right.
We keep directing it to one individual, it's not that department. It's not relevant.
Yeah, but if it wasn't for that department, it wouldn't be a push on this board to do anything.
No, I've actually been pushing it without that department. Because whenever we got rid of the previous fire marshal, we never replaced that job. And this is why sheriff department's running around looking at fires, getting responded. This is why we keep calling the fire departments out. We're not doing it properly. So we get the fire marshal to do it properly.
And respectfully, I don't mean this disrespectful to the last gentleman, but he was not a true fire marshal. This would be a fire marshal.
Yes.
He was just a man with the title and did the best he could.
We should have replaced it back. Here we are now.
Yeah, I mean, as long as that item gets added on there, I've got no problem. If you don't think it needs to be done, we can just direct her to do it, that's fine. I agree that we've never done it, but we probably should have. This board should at least look at, review, and approve all job descriptions for everybody. I think that's part of our job. I don't know that means that if something needs to change, there's no real consequence that can't be handled in your office. But whatever, as long as it gets done and added to the job description and the qualifications, I don't have a problem. I don't think you want to do that.
Your call, Commissioner, no action, as long as it contains the language you talked about.
Yes, so that means that additional qualification or requirement is that they have to have plan review, certification, or the ability to obtain it within 90 days of employment, and then mixing just his residency requirements to the Wilson County, Wilson or adjacent county. That's big,
Adjacent, contiguous, whatever.
Okay, so take no action on agenda item 12 with the notes noted to HR. Agenda item number 13.
No, we're going to let
I'm sorry. Agenda item number 12. We have Commissioner Mark, Precinct 1, discuss take action on fire marshal's salary. I'll take note before we go any further. We voted on that. I'm not sure how we're going to ratify that today. It's already been voted on.
Well,
and approved unanimously by this board.
Well, yeah, I know, and that's a little bit of a problem, because depending on the qualifications of the person that's recommended to us, and if they currently have all the certifications or not, it might be that they need to get the lesser salary than that. I think we can amend that after we discuss it, when we have someone to hire the person who meets the requirements, and they have all the required background and certifications, and they can get that salary. If they don't, and there may be something else in that, so they get that certification.
Okay. So let me ask the HR question. We've already posted the salary. Does that mean there's some leeway there if we decide, or is it, once it's posted?
It is posted, and I'm going to defer to Brent on this one too, just because a position is budgeted for a certain salary does not mean that it has to be paid to maximum capacity either.
No, it just cannot exceed that salary, but I would caution the board to consider, though, if you're going to change or reconsider, you may have applicants who applied, because I heard Jalen say she had 4 already who applied knowing that the salary was posted as such.
Correct.
So I'll
And what I would say to that is during the course of the interview process, that we would go, this is a max. If we establish a window, I don't know what number that you have, but if it's a window that is, because you had previously said, I think 20 below and 20 above was what you found
Right.
out there, we're right in the middle. And so if you wanted to go, okay, at the discretion of the board, they can make a suggestion and they can discuss it with the final candidate and the secondary candidate, that based upon your qualifications and where you are, we'd like to offer you the job at this. Is that what the court is looking for?
Yeah, I think so. That would seem most appropriate to me, because I mean, none of us know what qualifications the candidates have. And until you know that and you talk to them and not see how much experience they have, I mean, we don't know what those salaries were for a 5-year person experience or 55 years of experience. I mean, there's a lot of things to me that enter into that when you're going to hire somebody and offer them a salary.
Well, we got a job description, I mean, that's what we're hiring to.
Right.
So if they meet that job requirement, are we not paying them the salary whether they did 5 years or 5 years?
And I would just for clarification, we do not do that for any other stated budgeted position in this county. So, for example, if Sheriff Stewart has deputies or investigators or lieutenants, and the starting salary is, and I'm just throwing a number out there, $60,000 a year, the likelihood of Sheriff Stewart hiring someone less than that amount based on how many years of service they have is probably pretty slim. So unless we're going to do that for all budgeted positions, because we don't have scales. Unless we're going to change our system to have scales, that.
But I have done it. Whenever I've had an individual come in who we will call green, did not have as much experience, I hired them in at a lower level than what that position had available.
Sure.
And then told them what they needed to do to achieve it, and then I would take them and work on getting them additional monies. Or, I know Commissioner King and I have both hired men at times past that didn't have the ability to drive a commercial truck, and we paid for their training, and their salaries were lower to offset the fact that the county paid for the training, and until such time as we had it paid off, we weren't going to do anything else. I get the wisdom in being able to give yourself leeway, and we may have a bunch of candidates that show up that they all have 30 years of experience in being able to do one of these things and not necessarily as much in the others, and that would be a decision-making process on the panel to go, what do we need, or where do we really need this training? But
I think that the fact that this individual has to be dually certified would make them qualified right off the bat. And that's just in my mind, because they're not only fire, but they're law enforcement and they're EMT.
Yeah, but
So really triple
is not required.
to be fired.
Ms. Huron, I'm going to need some help on parliamentary inquiry. We voted on this. Are we assuming, we're saying, as the court, cap us that amount that we posted? Because we unanimously already voted on this. What's your direction?
Well, and the court did vote on a salary, maximum salary for this position. After interviewing and making a determination on who they select, the individual may say, yes, I want it, but I'd like more money, or I want this extra benefit, or whatever. Then it has to be reviewed by the budget, but then it can come back to the court to revise the salary because of a particular candidate. So that can be done later, depending on what the candidates and the interview process and the qualifications. At this point, you do have to set them out. So kind of, unless you change it by vote, that is the salary.
You know,
And that's what that right now.
I'm going to go back to my previous job as commissioner. The Governor, and I had to interview a lot of executive positions. They knew what it was 110,000 a year. They always came in and said, well, I really will come after the interview was done and they were selected. They would come back and say, well, I really can't come here unless you pay me 120. And I've shown the door. Go back, find another work, so here's how you want to deal with this. You assume this is the starting rate that we put out on the website, or how do you want to handle this? It's already out there.
I'm not sure it is. I mean, that was my only point is that if all the applicants came in and none of them met all the minimum qualifications, you wouldn't want to pay them that. That's all I'm pointing out here. I think it was a mistake to set a salary we probably should have done range because we don't know what the qualifications of these individuals are going to be.
After seeing the applications that have come in, that's
Okay, well, that's your opinion today, and that's fine. But my only point is we probably shouldn't have done it that way. And I think we need to reserve the right to go back to Commissioner Ross says, we'll evaluate. It might be that somebody wants more. Maybe they're the best candidate. They say, no, I'm not going to come for that. I want this, or I want extra holidays, or extra vacation, or something. And it'll be up to us to decide what that is. So I just caution us going forward on setting these things that restrict us because we don't know what we're going to do. So I have no problem moving on. Just want to caution you going forward, we need to make sure that person's qualified and that meets the requirements for the salary if that's what we're going to pay. If they don't have all the qualifications, then they shouldn't get that max pay until they get that. I mean, there's a lot of places that hire people. I mean, let's just take the tax office, for example. They don't, the first day that they walk in there, they can't do it. They've got to go through all that training. It's just like, if this person that comes in, they do everything, they meet all the qualifications, wonderful, and they get the full salaries. But if they don't, then they don't get the full salaries. That's all I'm saying.
Well, my suggestion is the committee take that into consideration when they're choosing their candidate. Absolutely. Okay. No action on that. We move to and item number 13, Commissioner Martin, Precinct 1, discuss take action on approving the appointing Precinct 1 Reserve Deputy Council.
Councilman Morales. So as we left this, I believe, 2 court sessions ago, we asked him to bring his policy to the court so that everybody can see it. So it's in the package. So I don't know, Councilman Morales, did you want to open up with anything?
Only that the last time we did speak, we discussed a policy specifically for reserve deputies or support officers. I came up with this, reviewed it, and went over it with the county attorney's office and sent them a copy, and they were able to review it, and we approved it. Prove it was okay and move forward with it.
All agents who post $2,500 a month.
Are they? I'm sorry?
Are they capable of posting that?
Sure, yes.
Also, in our conversation, you indicated that the only, their only duty would be to bail within the court. And this covers what they can do off duty, which is basically nothing except traffic control.
You sure this court that they won't be working more hours off duty than they will contributing to the county?
Can I assure that?
Yes, sir. So it's possible that
They're off-duty jobs?
Is it possible that they would be putting more hours in on off-duty employment than they will contributing to the county.
It's possible that's the way they would make a living.
So we're giving them a commission so they can make a living off the lead.
No, we're giving them commissions so they can volunteer their help or volunteer their services to help us with Medicare. Unlike a midnight precinct with benefit.
Excuse me, Judge, in reviewing the policy, because I inquired about that, about their off-duty position, and I believe the policy states that they are not to work in other law enforcement capacity, on their off-duty hours. So if they work at USAA, doing insurance claims, that's completely different. And I think, yes, they may work more hours working at USAA doing insurance claims, but not as law enforcement using the Wilson County Commission. I believe that's the question, and that's policy.
So I do know the gentleman that owns the company that works on the employment of traffic control in this area here in Tuscaloosa. His requirement is they be peace officers. And that's how they don't have to abide by the Private Security Bureau license. Otherwise, they'd have to be licensed by the Private Security Bureau under DPS.
Well, I would assume that doing traffic control is a law enforcement duty, and I believe this policy provides that they are not to be doing it when they are volunteering their service to Wilson County. It would strictly be for support duties or whatever you need it for. That would be their law enforcement duties, and that would be exclusive to Wilson County. So they would not be able to do anything else.
Or it's the rest of the county. I know that there's things in there that they have provided so that it doesn't stop anybody from it.
That's correct. That's correct. And the policy does provide that if they're engaged in working for the county and they are an agent of the county, and if something happens, then yes, there's a lot of issues. Even though they're on volunteer basis, they're not getting paid, they're still agents of the county.
I give you a little time to read through constables policies.
I have a question regarding insurance, maybe interim, if you could clarify. So if I remember correctly, the recommendation or what we stated, Jimmy, was that they were going to be driving their own personal vehicle, right?
All they're going to be doing is payment, so they'll be driving wherever they're at, to the courthouse or to the.
Oh, okay.
Yeah, they're not going to be doing anything other than the.
So no, they're not going to be
There'll be
serving
some
papers.
papers,
So, never mind.
Yeah, but just to that end, if you wanted one of them to go with you, they would ride with you.
In some cases, I will have one of them with me, in cases of eviction, execution, things like that, I think it's going to be more than at least one officer. Other than that, that's the extent of what they're going to be doing.
I can tell you also that this policy very much follows the volunteer policy for the county.
That's all.
Aside from Bear County, which is huge, we have the constable come up here and help us out with this stuff. Do you know of any other county constable of our size that has a sort of deputy constable?
Yes, sir.
Which ones?
Precinct 1 is Constable Brian Nelson out of Cornish County.
I can tell you, Atascosa does not have it.
I don't believe council was.
No, they don't. Your friend Judge Q took them all out, but
Correct. All right, I'll entertain a motion.
give me the names of the four.
Yeah, the four right now that I have, my name is Stephen Moore, Russell Gutierrez, Lorenzo Pereira, I'm sorry, I can't remember that. And, Macayo Ramirez.
Again, Macari,
We call him Matt, but Macayo
Ramirez. Ramirez,
Ramirez, that's what I'm saying.
I'll make a motion to appoint Stephen Moore, Russell Mattingly, Elizabeth Rivera, and Macario Ramirez as reserve deputy constable.
Sorry, Commissioner, Russell Gutierrez.
Oh, Russell Gutierrez, excuse me. Correct, and Russell Gutierrez, not Russell Mattingly.
Motion made by Commissioner Martin, do we have a second? Well, for the second time, do we have a second? Hearing none, motion dies. Agenda item number 14, we have Brenda Williams, County Auditor. Discuss and take action on a resolution for fiscal year 26 EIDC improvement.
This is the resolution for our indigent defense improvement grant, that pays 20% for starting in year 5 for our 2 indigent defense coordinators. Judge, would you like me to read the resolution?
Yes, please.
The 2026 Wilson County Resolution Indigent Defense Improvement Grant Program, whereas under the provisions of the Texas Government Code 79.037 and Title I of the Texas Administrative Code, Chapter 173, counties are eligible to receive grants from the Texas Indigent Defense Commission to provide improvements in indigent defense services in the county. And whereas the Commissioners Court authorizes this grant program to assist the county in the implementation and the improvement of the indigent criminal defense services in this county, and whereas Wilson County Commissioners Court has agreed that in the event of loss or misuse of the funds, Wilson County Commissioners Court assures that the funds will be returned in full to the Texas Indigent Defense Commission. Now therefore be it resolved in order that the county judge of this county is designated as the authorized official to apply for, accept, decline, modify, or cancel the grant application for the Indigent Defense Improvement Grant Program and all other necessary documents to accept said grant. And be it further resolved that Caleb Otto is designated as the program director and contact person for this grant, and the auditor is designated as the financial officer for this grant, adopted on this 28th day of July 2025. And just for reference, outside of that, we are in year 5 of this grant, and I'm working with our district judge, Jennifer Dillingham, to come up with pro rata shares, because these 2 positions provide services within all of the districts in our county, and so the other counties now will be splitting the cost with Wilson County. So just wanted to give you that heads up.
Commissioner, I'll entertain a motion on this resolution.
Make a motion that we adopt the resolution as presented by the auditor for the fiscal year 26 TIDC program grants.
Motion made by Commissioner Aiken, second by Commissioner Keen. Do we have any other discussion regarding agenda item number 14?
Yeah, so what you're saying is we budgeted for all of it in the past, and we got 20% grant. Now each individual county's cost is going to be in there, and each county will get 20% of that amount reimbursed for what?
No, so originally in year 1, it was 100% funded, and year over year it was reduced by 20%. So at the time, it was agreed that Wilson County would cover that up until once the grant period ends. And so I made the recommendation or requested from our district judge if they would consider, to be fair, instead of Wilson County paying for it in full, if the other counties would pay their portion, to which she agreed. So I'm working on the formula now, because it'll be based on percentages, just like our district court budget is done. So it is for the 100% of their salaries, the two position salaries, benefits, and then they have a very minimal operating budget for the 5.
Any other discussion on agenda item number 14? Hearing none, I'll call for the vote. All in favor say aye.
Aye.
All those against, nay. Ayes have it, motion passes. Agenda item number 15. Discuss and take action on allowing Guadalupe Valley Family Violence Shelter Incorporated to continue utilizing the unused space classroom at the Wilson County Courthouse Annex 3 building located at 1103 4th Street in Floresville as an in-kind donation. Commissioner, they have been using this since this classroom since 2019, I believe. And we haven't had a contract with them since then. I mean, it was 2019 or 2020, I can't remember. Judge Jackson.
It was kind of a continuous, the contract provided that it would continue.
Okay. So that you're aware, they have been paying $750 a month, and they are a nonprofit that does a lot of work for a very needy cause. They do a lot of interviewing there for family violence. They do a lot of work for the county. Again, we don't do this for coming over the house. We offer a lot of services for us. And so I would ask that we give them that in-kind donation and allow them to stay in that classroom, which we are not using and will never use.
Do they use that restroom?
Yes.
Is that included in here, so that they have access to those restrooms?
I don't know, there may be an inclusion into a common area.
Oh, yeah, they're configured as that now.
Okay. Yeah, I can assume that it's the same contract that was initially
They're,
signed for $750. It's just that now there is not going to be any rent charged to them. It wasn't really rent; it was really their portion of utilities, which was the $750 a month. So their conditions, the liability conditions, all those conditions continue. It's just that they're not going to be paying, and it is a year that you or terminated. At any point, the county decides they do need to use that room or facility, the county has the ability to terminate that. So, no.
I'll entertain a motion to agenda item number 15.
I'll make a motion to allow the Guadalupe Valley Family Violence Shelter Inc. to continue to utilize the unused space of the Wilson County Courthouse Annex 3 building located at 1103 4th Street, Floresville, as an in-kind donation.
Second.
Motion made by Commissioner Martin, seconded by Commissioner King. Do we have any other discussion regarding agenda item number 15? Hearing none, I'll call for the vote. All those in favor say aye.
Aye.
All those against, nay. Ayes have it, motion passes. Agenda item number 16, discuss and take action on requesting the City of Floresville to remove property purchased by Wilson County, 365 State Highway 97 East, Floresville, Texas, formerly owned by Baning Enterprises from the ETJ. Approval and request by the Wilson County Commissioners Court is needed prior to submitting to the Floresville City Council. I've spoken with the mayor. This has to be the first step. We have to ask for that, and then they will take it to the City Council and present it for approval.
They're going to continue to provide water and sewer service out there.
That's correct. The septic will be for the next one. And that's the reason why ETJ doesn't allow septic.
Right.
I'll make a motion, to remove the only owned Banning Enterprise property, Wilson County, Oklahoma, from the ETJ.
Motion made by Commissioner King, seconded by Commissioner Cardova. Any other discussion regarding agenda item number 16? Hearing none, I'll call for the vote. All those in favor say aye.
Aye.
All those against, nay. Ayes have it, motion passes. Move to agenda item number 17. Ms. Lou Zarato, Permitting and Development Director, 17A, non-standard plats and variances.
Judge, 3 minutes away from the 10 o'clock.
Thank you. All right, let's just hold off. Sorry, we wouldn't have enough time. Thank you for reminding me.
I waited for him to stand up and start talking.
Thank you, Commissioner, I appreciate that. Yes. You ready to go? You'll be on scene, correct, Commissioner? Okay. Yeah, absolutely.
I'm just waiting.
We're waiting on it. Wait for a second.
Waiting on the tip. I'm ready.
All right, it's now 10 o'clock. We'll go back to agenda item number 6. Commissioner Mark, precinct 1, open and read aloud for the Mariana Road construction project in precinct 1. Yes, sir.
And we got one bid where we had, what, 9 people picked up twins? This is from, Elsinore Total Transport. And the form is here. project bid is $228,980. We'll give this to the county engineer to review for completeness. And our recommendation to the board.
When you say the number again, sir,
228. Yes, yeah. 228,980.50. And that's to reconstruct about a little over half a mile of road.
$228,980.50.
Yeah, could you come up? Just want to point out, this is under our engineer's estimate, so. Oh, good, good. Right, if you don't mind, maybe spelling of your last name. J-A-S, Kid and Tom, Jasper. Thank you. Do you have any other discussion on this? No, we're good. All right. Now, Mr. Apple, come on up. Agenda item number 17, we have 17A non-standard tax variances will go to 17A1, County Road 344, 140, non-standard plat, develop, discuss, and take action.
Good morning. So this was reviewed by our Wilson County Development Review Committee and given approval. Mr. Cordova did present the utility letters stating that the utilities are available. What it's going to do is essentially split into two tracts for 3.98 and 6 acre tracts. They had all their information provided. Like I said, it was given a favorable recommendation by the review committee.
I'll make a motion to accept this non-standard plat, County Road 344, 140.
Second.
Motion made by Commissioner King, seconded by Commissioner Aiken. Do you have any other discussion regarding 17A1? Hearing none, I'll call for the vote. All those in favor say aye.
Aye.
All those against? And Commissioner Cordova abstains, correct, sir?
Yes.
All right, yes.
And so do I.
And Commissioner Martin abstains. Okay, so,
You have to chime in.
you have Brexit time. Motion passes.
Extension's not a no vote, is it? But I mean, it doesn't have any vote, you know.
But that brings it down.
Two extensions and two.
It's not a no, I mean, that was my
Yeah,
not no.
but it is tied, so.
No hurt, no foul. It passes. Agenda item 17A2, Hidden Ranch Court, 171 variance on setback, discuss and take action.
So this is an actual variance. This was also given a favorable recommendation by the review committee. But before we get to that, let's just state the obvious. This house was built before it obtained any development permit. It was essentially built within the setback. Now, the setback that it's encroaching on is not the county setback, but it is a utility setback on the site. The utility company, however, did release their easement and provide letters that they're okay that the house was built on their easement. The house is already there, and in order to proceed with their development permit or get their development permit signed, they need to obtain this variance from the county, accepting that they have, essentially built in the setback that was platted.
Are these developers or actual homeowners?
These are home builders. As a
The way
developer,
they have it worded is this, in order to build my home. but
Yes.
it's not, these are developers.
Well, actually, yes, well, he's not the developer of this subdivision, this is the actual home builder that's building in that,
Developer home builder.
he owns those lots also.
So he just didn't wait it out when he started the
That's
project.
correct. So they don't get development permit time, they don't get their septic permit, so pretty much push everything to a halt. So at this point, they're asking for a variance from the county.
Are we doing a better job of watching over this so it doesn't come trickling in?
It's always gonna happen unless we put the information out there and educate the public. We're always gonna have people that come in.
That's why I asked the questions I did. This is a builder's problem. He was lazy. He didn't lay this lot out the way that he should have when he built this house. I mean, it goes without saying, you can talk to Jill, I am firmly against this because it is not up to us to fix his mistake. That is, to me, that is his problem. He should bear the cost of it. And that's just the way I feel about it.
The way that the review committee saw it was that we do have, pretty much a citation for people that are non-compliant with development permits. The citation is $500. Well, that is also the application fee for a variance. And so the way they saw it is like they paid their $500, they're coming and asking, the county now.
What was the house built?
When was it built?
It started a while back because I called them to ask them in, February, March-ish
Of this year.
of this year, yeah. And then the first thing they said was, we don't have a development. And at that time, only the slab.
I think I
They've
remember
gone on and they've
you
built.
brought it on in Commissioner's Court at some point, I think you
No.
discussed.
Well, I might have mentioned it, but yeah, I mean,
We do have a lot of misinformation that's put out there. A lot of people that are selling land, they come by the county, there's no restrictions. Yes, we don't zone, but no restrictions doesn't necessarily mean that there's no permits that you need to obtain. You know, the county has R3 permits, septic, development, and driveway if you're in our county road. And now fire if you have a commercial building. But that's the miscommunication that's out there, and we would like to, at some point, put together some forum or try to educate the public, the real estate agents, the title companies, just because we do come across these problems a lot.
but I blame the developer's son too, because they are selling these lots before they even have the roads completed, which they're really not supposed to be doing. That's what our rules say. So there's a couple of ways that we can work on enforcing this, and so I think, based on the discussions I've had with Mr. Otto, they're going to start handling it on their side and come back with some new application fees and maybe some potential fines for us to approve to slow this down and people's attention, because, it's unfortunate because now someone is going to be paying, believe it or not, $500,000 for this house that has variance, which means every time it goes to a bank, they're going to make sure that this variance is there. Buyers are not going to know that probably, and it's
And that's
just
where
going
they
to
come
continue
across
to be a pain in the
So
neck
this is
for us.
a home builder, and if they try to sell this property, their lender, their bank, is gonna want to see that we essentially gave it the okay because it was built incorrectly. So if we don't do that, then this house is just there, already built. This is neat.
And the one coming up next, it's the same thing. These folks are trying to sell this house in Civil Ridge. It's building built on utility easements. And they would sell it,
The bank for-
and that says,
No,
ain't happening. So it's a problem in our county, people moving forward without proper permits. And I don't know exactly how we can stop it. I understand they're paying $500 for a permit, but I would be in favor of a $500 fine or better as well.
no, more like 5,000.
They just come in there and they pay $500 to get their permit that they should have gotten to begin with. Yeah, there's really no consequence to their wrong action.
No.
Problem is, you're going after an unsuspecting homeowner rather than the developer that you need to be
Well,
going
in
after.
this case, this is the building.
And
This
I mean,
is the building.
it's in front of us, we don't have, I'll leave it at that.
That's the other thing we did have a discussion during that meeting is, you make it a 5,000, how do you
concrete slab poured on the ground.
It's more than a flat now.
Yeah.
Yeah, that's the one that we're talking about. This thing is basically done except the interior finish up. Wall rub.
So they're not gonna tear it down, but
painted. Yeah.
you know, it's up to us to decide. Either give them the
I thought your
variance or-
suggestion was pretty good from what I heard, and that was just cut that part of it off.
They didn't like that.
I'm sure they did, but I mean, again, you know, I mean, it's all in them. They're supposed to know this stuff. They're the ones that are supposed to be the experts. You know,
And if they'd been in Bear County, where would they be? I don't think they could issue the variance in that county. I think
I would have finished the fine on top of that. I mean, I don't know that they would have asked
they
me
should
to.
find it, they may have had to tear down that. Yeah. How many
I
feet
mean,
over that? The thing is that of course we don't want to really compare ourselves to our big
And again, this is not the county setback, that our setback is only the front.
it's irrespective of that. I mean,
But it is flat.
it is ours because we take their standards and they put it in our plat and in our plat notes. So it is basically a
So it's
counter.
up to us to enforce it.
It's up, yeah, because obviously the utility companies don't care.
Well, I mean, Mr. Elmer probably needs to visit the state fine for that.
Yes, I mean, you have the developer that is doing it wrong, and they can be sanctioned with a fine, some kind of substantial fine to make it a deterrent not to do it. But as Commissioner Aiken, sometimes you have a homeowner that buys a non-compliant piece of property, and they can't get financing or do anything, and they have been misrepresented by their real estate agent or whoever, and now they're having to suffer the consequence as well, because somebody asked for the variance or something that they had no, so there should be something to distinguish, what the problem is, but I agree, I think there can be some substantial sanction to make it a deterrent to do this and it's going to cost.
Yeah, this next one, Civil Ridge, is supposed to off this property, and it wasn't caught when they bought the property. Now they're trying to sell it, and it got caught.
Yeah, and the
These people are like, we bought this property, we did not know, and now we're trying to sell it.
And that's
Let me
what
look
on
at
the
title search
Yeah.
and the
Yeah.
original transaction.
See, and that's a little bit different terms, okay?
Yeah.
And back to this, your point is that we have a problem, we have ongoing problems. We still have problems on County Road 124 in this development. We finally got a plat submitted. But the thing is they're not in compliance. They don't want to be in compliance. And they don't want to listen to us. They think they can do whatever it is that they want to do. And so we've got to put more teeth. We've got to make these people more serious. Our plat fees need to go up. And we need to get serious about these fines. And I appreciate what you say, Commissioner, because I mean, I don't like comparing us to Bear County either, but you know, one of the differences is they have a whole lot more resources. They got people out there, that's their only job. They're driving out
Yeah, they
there.
got people riding around checking that every day.
You know, yeah.
We don't.
Whereas we're the 4 or 5 of us, and maybe our foremen are the ones driving around, and if they see something, and they might question it. You know, what about the ones that are a half a mile back in a piece of property that you can't even see from the road? You know, there's lots of them that go that don't come and get their development permits like they should. And to me, when you completely negate the rules by not getting your permit to start with, to me, all bets are off. I know I'm strict on that, but that's the way
Ms. Council Committee,
It did pass the review committee.
I think board will need to be more vigilant on that, and we need to get with you, Mr. on how we can impose a very strict fine for this. Some of those developers get the work, they're going to have to. All right, we have an action item here, 17A2. I'll entertain a motion.
I'll make a motion that we grant the variance to Hilton Ranch Court in 71.
Motion made by Commissioner Perdomo, seconded by Commissioner King. Do you have any other discussion on 17A2? Hearing none, I'll call for the vote. All those in favor say aye. All those against nay.
No.
Hey,
You have time, right?
No, and
Yes,
I
or no?
just answered it. So yes, it is a tie to.
I vote in the affirmative. It passes. Agenda item number 17A3, Signal Ridge, 264 variance, Curry, discuss and take action.
So this is the one that Commissioner Perdola was talking about, essentially the same situation, but unaware from their builder, they built a shed in the back portion of the setback. Again, same thing, utility letters releasing the easement, saying that it's not a problem for them. But they're trying to sell it, you know, that they need the approval from the county in order to go forward with it.
And the utility company has no problem?
No, they do not. They did supply letters from both electric and water stating that it's not a problem for them.
And these people bought this property as is, and it was not caught at that time by the title company or the bank, and now they're trying to sell it, and it got caught. What's the distance? It's not written in the application on what the encroachment is.
Both
Five feet on
very
the side.
yes.
Keeping questionable company. And this is entirely different, and, you know, you heard plenty of back and forth. There's something where discussions with the title company on why was this not found in the original purchase are one of those things I would think would be in order. And this is not an oversight on the developer's part, that we have encouraged them, we've asked them, we've told them, you need to show up and you need to do it right whenever you're doing business in Wilson County. We all battle with contractors to this day that show up and dump stuff into the county road. And the reason we made them get a driveway is get your vehicles off of our county road and do your business on that service driveway to be able to build that home. And, you know,
This
so
is a matter of finding a contractor and assuming, you know, that the contractor's taking care of all the permits and following all the
Well,
factors.
I think in all fairness, it said this is a shop, so that was probably built after the house.
it was.
It was, but it was also built with a different HOA, built for
Yeah.
and a neighbor.
And these folks just have to be caught in the middle.
Yeah.
Can't
Well,
sell the home.
For all the developers and builders that are listening, make sure you know where your setbacks are.
Absolutely.
Because, I mean, and they're the ones that should be coming to you and asking you. And I know, they don't, all they're out is after the almighty budget. I gotta do this, get over here, get done, get out of here, and give me my check. And that's all they're interested in.
All right, Commissioner, I'll entertain a motion 17A3.
I'll make a motion that we approve the variance Seminole Ridge 264.
Motion made by Commissioner Perdola, seconded by Commissioner King. We have any other discussion on 17A3? Hearing none, I'll call for the vote. All those in favor say aye. Aye. All those against, nay.
Abstain?
One percent. Okay. Motion passes. 17A4, Shady Lane 405 variance, John Van, discuss and take action.
Yes, I do want to say that the line is here in case you have any questions. It's the same situation, request for keeping the setback, the house was built in one of the setbacks. So this one has an unusual setback. It is the front, but this particular subdivision had an unusually large setback. So when the house was originally built, I guess the same thing, home builders didn't look at the plat and didn't realize that the setback for the subdivision was set so far back.
75 feet, is that correct?
Yeah.
75 feet, yeah, so that's 75 foot setback, so.
That was the developer's decision, because we've never had a setback requirement.
Yeah, I mean, it's,
So that's more of an HOA.
Is there an HOA or supposed to be an HOA here?
yeah,
No, there's not an HOA, sir, that voluntary HOA. Oh, I'm sorry. Oh, sorry about that. Yes, sir. It's a voluntary HOA, there's really no HOA that's trying to get My name's Isaac Alban. I'm a 405 Shaker Lane. There's haven't been able to get a hold of any issue. It's a voluntary issue, from my understanding. There's no issue there.
Are you the original owner, Mr. Gray?
Sir, it was me and another person, and then I find the other person, builder. Apparently we trust, but I'm with Commissioner Martin. They should find the builders a little bit more because we put our trust in them, and then we're the ones stuck with the problem. I'm to be here and doing all this.
Yeah, and I hope you know the commissioners are not attacking you personally.
No,
They're making a point against the
and I appreciate that.
How did you find out that the home was set back?
Sir, I was trying to refinance the property on it. When I did, that came up on it, trying to refinance this. Cancel the property, so trying to go ahead.
Missed again prior to.
Correct. So, that's a problem right now.
So when was this house constructed?
It was built about a year and a half ago, sir.
Did they get a permit?
I'm sorry. Yes, Shady Lane is private lane. It's not one of those deals on Lake Valley where the road didn't pass. Yeah, back in the day. So
Our commissioners are entertaining a motion on 1784.
I will make a motion to approve the various 405 Shady Lane development. Second.
Motion made by Commissioner Federal, seconded by Commissioner Aiken. Any other discussion on 1784? Hearing none, I'll call for the vote. All those in favor say aye.
Aye.
All those against, nay.
Abstain.
One abstain. Motion passes. All right, sir, thank you. 1785, County Road 422-577, variance, Lada, discuss and take action.
So this is a current, different situation for variance. Ms. Letta is here in case you do have any questions for her. She built 2 homes on 1 lot in, the subdivision. She has 1 home that's currently under contract. So what she's establishing or trying to establish is a condo regime. We have had that come through our review committee before. What she's trying to do is just sell the 4 walls of that 1 structure and assign them responsibilities for half of that tract of land. She does have the intention to come back and replat it per the county's regulations so that they will ultimately become owners of half of that tract of land in the subdivision.
You have the condo paperwork? You turned that in?
Yes, they did turn in condo information. And it was filed.
That's what my question is, why don't we just do it right to begin with? We know if we do this, that they're coming back to us again for a reading.
I think the regulations have not been met to just do it that way.
Yeah, an official replat would require a plat, water study.
Okay. Regulation right now.
So,
Well, doesn't this stem from, there's only 1 septic tank for both homes?
There was 1 septic tank. We've been made aware that they are in the process of installing a different one. They still have to obtain the permit for that. But they have disconnected it from the original one, and they are planning on putting in another septic tank for the other house.
So they don't have a second, I asked this question the other day, but I don't know the answer right now. So they don't have a second tank installed for the second home?
No, not yet. There has not been a permit pulled for the second tank. The one that's under contract, that's the one that has the existing septic tank.
In my opinion, I would be inclined to move forward on this until they at least get the.
Like I said, they do have, they are here, and they have a representative here with them if you have a question.
you may come.
Good morning. My name is Maria Quiroz. I am the representing realtor for the homeowners here. Initially, this was offered as a two-property portfolio, multi-generational type of deal. And we got a contract for one of the homes. What I find here is that it provides affordable and attainable housing for buyers that are being priced out. Buyers that are being priced out looking for a dwelling with just your conventional less than a quarter-acre lot. So it provides this opportunity for these type of people without, most importantly, compensating the rural structure and integrity, and at the same time providing little to no burden on the county's resources. So we thought it was a good, just a good kind of strategy to come up with a condominium regime.
But you still have to follow the rules of the county. You can't go in there. There were two homes built on one lot, one septic tank for both homes. You can't do that. So somebody should have done their homework before this property was sold to this unsuspecting lady. Now that she's dealing with having to go and put a second septic tank, you are asking us to approve this, and you still don't have a septic tank installed.
Yes.
You got to follow the rules. You just can't come out to Wilson County and do whatever you want because you think you're in the country.
No, I understood, and it is our understanding that the septic tank currently in place supports both dwellings. But since now we got an offer for one of the dwellings, and the condominium regime was drafted, the idea is to stop the line so they don't have anything to share, no general common elements. It's just, pretty basic.
One septic tank for both homes was never legal. What I'm saying.
Okay.
So I'm going to make an assumption. Track A is the one that is under contract, is the property that has the septic tank in place.
The second home, unit B, the one on the right.
Okay, well, right is relevant, so let's,
Oh, sorry.
we have two plats. One of them says track A and one of them says track B. And I don't know if you're trying to say that you need to be able to sell the home that doesn't have on the same property the septic system, or it does. You come up where,
They are currently trying to sell the one that has the existing septic.
okay, so that is track A that has the septic tank listed on
Yes, correct.
it. That's the one that's under contract. So, what does condo regime do in this instance? What is this a declaration of underneath what we have in place for our code and conduct?
So the issue is that it is in a subdivision, and the condo regime, like they stated, like provided contract for, what it's doing is essentially selling the four walls and assigning the responsibilities that only have the front. Now in a subdivision, that's different and unheard of. Again, this is one of those things where it's requiring bank approval, the bank is requiring county approval. So the only,
Refresh my memory, what subdivision was this? Because I know this road. Yeah, I mean, there's not a subdivision. Road 422, this crossroad, 421, is going to be on the south side of that intersection. There's going to be a home on the corner, and then there's going to be at least.
So is there an HOA?
No, there's not even a subdivision. I think these two homes are the only thing that are in the subdivision. I'm sorry?
it was platted as a subdivision. There is a plat that's on file, but there's no existing homeowners association.
Okay, so next
Oh,
question.
crossroads.
Who was the developer that did this? Because
This was started previous to Ms. Latta purchasing it. I believe it was started by someone else before she purchased this property with the one slab. Did it have one?
two
It had
two slabs.
Yeah.
Two slabs.
So this was
Here.
purchased and done before her. She came in and bought this property. as if with the slabs on there.
But did they get permits?
For the original ones, the original slabs were, yes, because they were both addressed, yes.
They have permits when they pour the slabs.
They had permits, when they poured the slabs.
And they probably should have got permits.
Those slabs have been there, if I'm correct.
You can have two residential structures at Crossroads subdivision, their covenants don't, restrict that.
But that's the only two houses in the subdivision.
Sorry?
That's only, those two slabs or houses now are the only two in that subdivision.
I don't know, I think there's more homes in that subdivision.
I think that they're calling the lots that are on 421 part of the subdivision. Looking at this plat,
This is Ms. Lara. My name is Heidi Lara. I see multiple houses being built for different builders and the big finish and everything. And as my person, I ask for all the permission. I get approved and everything. I hire somebody to do all the permission that I can have everything to do it the right way. Like that, I don't have to come back with this, and I come back with this, it's like, oh my God.
So let me ask you a question. You said you had a contractor.
No, I have somebody who do all the paperwork for, like, the permission, like the septic, the house, and also the dry well, the permits only for the Wilson Laundry.
We have one.
Yes, we do, because what we're missing right now is the new septic permit that, will be involved with other residential structure on the property.
it's 421. All those lots have 421 on the north side. I'm pulling them out.
Also, whenever we talk about this in the subdivision committee, is, you do plan on coming back and platting all this back out,
With,
correct?
Just these two.
So she understands that the intent was to sell the property, the entire property. When the lawyer spoke to her, she kind of told her on the fact that they could be done as a condo regime. When she came into her office, I made her aware that the condo regime only functions in a way that you only sell the four walls and assign responsibilities to the property, but you do not sell it. I told her you will ultimately still be the property owner, you still pay taxes, you are still responsible for that tract of land. That was not her intent, this is not the way she wanted to do it. So because there's already a contract out for this house, she decided to proceed with the whole condo regime, but she does plan to come back and obtain a replat from the county. So she will legally split the land and sell that without taking any more than what she's already gotten for the house, because they've already gotten an offer for the house.
I'm not asking for that right now, rather than the condo regime. What,
The replat process takes a little bit longer, it does have to be plotted out by an engineer, and it takes 3 weeks in the newspaper.
because in essence, when you look at it from Google Maps, you can tell that this property that the two homes are on that we're discussing is the same size footprint as all of the properties that are on 421, which is where we get our subdivision name without there being a true subdivision. And so, why make it hard? It's still going to be 1.64 acre tracts.
It's kind of I believe that you have it under contract, and that's in order to not hold back on the person that's trying to buy the property, so they've done it this way. But, like I said, replanning it would take longer, it has to be posted, and we have to make all the neighbors aware.
Has it ever been done where, okay, but in order to make sure that this is going to be done right, there's some sort of bond that is put forth at the transaction that goes strictly to making sure that the other property has a septic system installed. You know, I know it's in our best interest to get that done.
Mm-hmm.
It's just another one of those deals of we got the cart before the horse.
Yeah.
I mean, this never should have been done this way, and now we're dealing with someone else who was unsuspecting.
She already has the information, she said, for the new septic system, she's waiting to get that from the engineer to get filed with the county. But, I mean, regardless, we do not have any assurance other than her word stating that she will come back and replat. Ultimately, the decision of the commissioners.
Well, I'm just saying that it, I don't know how much time or how much funding she's had up to this point, but should have had the septic system on the second one done already, and this would have been an easier decision.
Like, she knew that she had to do the septic system to get the permit purchased. That would have gone a long way in this discussion.
Yeah.
So they, they have development permits for both, so they, the same thing, you know, they have the septic system, the plans are, they already hired an engineer who made the plans, and just waiting to get those submitted to the county. The plans, after she found out that it wasn't gonna be able to be done the way that the lawyer had explained to her, that's when she proceeded to find an engineer and have the plans made for the other septic system.
But I guess we're back to, how do we have assurance that if this gets approved, that all those things that need to be done will be done? I think that's the bottom line question today, so what can we do, Mr.
You can do a conditional approval, where you approve it based on the condition that whatever you want done is done within a period of time. And you state on the record what the conditions are and why you're not giving an all out approval and what conditions that you are requesting. And then that would impose a condition on them to fulfill it within a period of time, or it will deny, or the approval will go for, you can do a conditional, state the reasons and what you want done, and the assurances that you're going to, for it to go through.
Go ahead, Maggie.
Yeah, as far as the septic tank goes, it's part of the condominium regime document, and it is also part of the current contract that we have in place. That there will be, the both dwellings are going to be completely freestanding, with no general common elements or nothing, no utilities to be sure. So it is, you know, part of her, legal responsibilities.
Here's the other thing, just looking at the diagram. Once this is split from both parties, both homes are going to be able to have access to the back of their property from the county road, because it looks pretty tight.
They should. The property line would be straight in the middle, and each property owner has full access of their 1.6 acres.
But if it's split into two properties, the way that it's lined out, and we're dealing with setbacks already in this same meeting, are we going to be afforded enough room, or is it going to be something else that down the road we're going to have to take and approve an encroachment on a setback because of narrow properties?
Well, these residential structures are already permitted, and so those setbacks are being checked. They are not being approached at right now. And they're already.
But I think what Commissioner
It's a
is
single
asking
property
is,
right now, not
there's no setback where this new property line is going to be. So how much space does it look on the one to the north and the west? It doesn't look like there's much room to drive by there. It doesn't look like you can get by on the other side. I'm not sure.
Hey, 80, yeah. 80 feet.
Right now. That is a road going to another dwelling back there. It's going to this line. You can't tell what number it is. It's
The dwelling in the back?
yes.
There's an easement outside of the property line going towards the back of that other dwelling, which if we have, it's Mr. Vada too.
It does look like on the north side, well, anyways, this is Google Maps on the property that we're talking about. Whenever you take and split these two properties, you're going to be closer to one structure than you are to the other on the setback. It's probably going to be within 50 feet.
long does it take to get a replat? Start to finish.
I'm gonna say 60, close to 60 days,
Close
right?
to 60 days, yeah.
At least.
They have to go through the next review committee and then, they're supposed to take the consecutive
We
weeks
talked
and then
about this.
decide the additional ordinance.
We talked about this almost a month. That we even started. These are just questions, and thoughts. This was brought up, they're right hard to me. That's all I can say.
And I know, and I mean,
Okay, Commissioners, 1785, I'll entertain a motion for conditions, or however you want to pose it. Just put a motion out. I'll entertain that motion.
I just want to advise you that if you're going to deny or conditionally deny, or conditionally take very specifically the reason that you are not granting all out approval. Because then it turns into an approval if you don't specifically do that. Just that information from the Office of the Attorney General, that the denials or conditional denials or approvals have to specifically state what code provision or what regulation is the basis for a non-approval. So you know, on the version of the action.
And that's the reason I asked how long it takes to do a replat, because my really condition on this, if there is, whatever the motion is, accept or deny, we need to think about that time.
and is there anywhere else in the county that a condo regime exists? Have we ever done that before?
No, not currently. Though we have been getting applications that have been coming in through our department, but not currently.
So we've been getting applications that are using this same vernacular condo regime, which means that we can take a look at in our future, we're going to be dealing with even more of these type of situations.
That's correct.
Okay, Commissioner, your call. How do you want to do it?
Is there a way to do a conditional approval based on being brought up to compliance ahead of transaction? I mean, I know that's what, they're up against the time frame, but we're not the ones who establish that time frame.
And just state what the conditions are and the time frame, and what results.
Or does it have to be a time frame if the condition is that they have to establish a septic system on the other property prior to the bill being finalized and approval, then that's what they have to do. It's in.
Yes.
Yeah, but by the same token, they need to do the replat after that. And that's the one that's hard to put a time frame to. I mean, you can say within a certain number of days, but it's already, we already know it's going to take a couple of weeks probably for the engineer to put stuff together, then get it turned in, blah, blah, blah. And then she says it's got to be published and advertised for 3 weeks, and then it's got to be a public hearing, and then the results. See, and that's where I'm starting to have problems. So what if the results of that public hearing are negative, and then we've already approved it? That's where I'm at today. Okay.
Can it be contingent on the public hearing?
Well, but if they're moving forward and doing something, if the public hearing says no, we're against this, and that's the will of the public, then we've already allowed part of this to go through. And it's all a timing issue.
But if we take no action, then it's going to be approved underneath the law anyways.
Yeah, and that ultimately puts the burden back on my department to state why it was not approved. The same in non-standard plan. We can't just say no just because we don't like it. I mean, You
Well,
can
we
say
can
no.
say no at this
You
time
can
because
say
we
no.
don't have separate septic systems
Yeah,
on
absolutely.
the two properties involved. And I
But
mean,
my department has to answer
And I'm a
all
little
of that.
disappointed because she knew that she needed a septic system on the second property. That was discussed at the last meeting. And obviously, she hasn't moved forward on that. So what guarantee do we have she's going to move forward on the replat if she hasn't moved forward on the second septic system?
With that time frame right there, whatever you, it shall be done on within X amount of time.
It's not like this was a surprise about your second septic system. It was discussed.
Excuse me.
And move forward.
Since it was gonna sell two houses together, the septic is designed for two houses and also control the two houses. Then we have an offer and we offer the two houses on one side and we offer separate. And we say if we have to separate, to sell it separate, we have to pass the timeline that we can process with the other one. How about if the sale drops and somebody wanna come and buy the two houses? We have to connect it again. So,
No,
no,
you can't. You have to have separate septic systems.
all on no, but
right. And, I get it.
I think also, if you are gonna be seeing, I've been dealing with these single-family condominium regime type of properties for a while, and if you are gonna be seeing more of that here in Wilson County, the main, and just to kind of reiterate what I have said before, I think the main, from my perspective, the main benefit of this is that it does offer affordable housing to these people, to these buyers. Because once you consider, a developer considers the extent of replatting and the time of subdividing, then they would have to those prices into the sales price. That's just kind of, my perspective on this, and of course, that's not what, here my client is saying. She will come if that's what he wants, she will do that. But that's just my perspective if you are.
We appreciate those comments, but we have rules and regulations we have to abide by.
And our problem to date is condo regimes have been a solution to a problem, or a recommended solution to a problem. They're not starting out that way initially in being platted and permitted in that way. That's the problem that we have. It's a temporary solution.
This was not platted and permitted as a condo regime. The condo regime, as he stated, is a fix to a problem that already exists. So y'all are asking us to correct a problem that we didn't create. You do a condo regime, and then you're gonna come back and do a replat. So why don't you just do a replat to begin with and have it done like it should? See what I'm saying?
Well, I think that that's partially true, but I also think that what's true is that in other places, this is a solution to where they are truly building condos,
Yes.
which trade hands all the time.
And I think I said that.
And there's a management company that deals with the entirety of it, rather than
Commissioner Morgan and I both said it wasn't done originally as a condo regime. The
So-
condo regime is a solution to it.
we're gonna get to the same place no matter how I decide to take and word this, because I can either word it that we deny it on the basis that there's not a secondary septic system, and we will review it at a further date whenever that system has been properly permitted and is in place, or we take and try to make it sound positive and go, you can come back to us at such time in the motion that this is all done. I don't know. The semantics of it are.
I think you have one more option, Commissioner.
Go ahead, sir.
I think that this is a nice sort of request, that
they've got a plat.
That's the ultimate solution.
And I mean, that's where we're gonna end up anyway, so why not take and get there anyways? And I agree.
All right, so I take Commissioner Aiken, you make a motion to deny.
I'll make a motion that we deny it until a replat is done on the properties, at our permitting condition. In accordance with what we already have established in the way that we conduct business in Wilson.
Does that put us,
Based on what regulation
Okay. Our regulation that states that each individual home will have a septic system is not being met in this request, and therefore denied it on that basis. And setbacks. And appropriate setbacks as per Wilson County. That's a lot of stuff. I will say it correctly. Okay.
All right, motion to deny has been made by Commissioner Aiken, second by Commissioner Curdo. We have any other discussion on 17B5? There are none, call for the vote. All in favor say aye. All those against, motion to deny passes. 17B, I'm sorry? Curdo. Agenda item 17B, utility permits, number 1, permit 810 for Coastal Precinct 1, County Road 124, review and approve.
Okay, so we had this with Francis Schwartz. We got the questions answered, and the water line is for their residence home. And since I know, and I don't know if y'all are different, but I know now that y'all are requiring a separate meter for RV in the home, correct?
If the RV is going to be a permanent residence,
If it's a permit, okay.
Which is
So
established
in the
90 days.
future, when you, yeah, so in the future, when you submit your applications for permits before the road or whatever, would you make sure you state that in there so that when we go look at it, we know?
that it's for an individual residence,
Yeah, 'cause like
one
that,
resident.
you weren't here last time, that was my question, was this is for the residents, because we heard the residents was out of compliance, and there was an RV parked there. So, and I doubt the RV was parked there when you guys went by there, so I didn't know.
I just saw it the other day for the first time. I do apologize, Marty, rural manager for Coastal Water Supply. So state laws, the rules that we have to follow is an RV can be temporarily serviced as long as it is not for more than 90 days in a calendar year. It's still considered just a temporary residence, a guest residence. So a lot of times if somebody is building a home, they may park an RV out there while they're building the home. So that one meter will serve the RV. As soon as that home is built, the RV is no longer serviced. If they still continue to supply water to both locations, they are required to get a second meter. So this, at this time, the permit is only for 1 meter to serve one permanent residence.
Okay, so I'll make a motion to approve permit 810 for Coastal Precinct 1, County Road 124.
Motion made by Commissioner Martin, second by Commissioner King. Do we have any other discussion regarding 17B1? Hearing none, I'll call for the vote. All in favor say aye.
Aye.
All those against nay. Ayes have it. 17B2, permit 814, Sunco, Precinct 2, County Road 223, review and approve.
I've already been out to, this location on County Road 223, so I make a motion to approve permit 814.
Motion made by Commissioner King, second by Commissioner Curdo. Do you have any other discussion on 17B2? Hearing none, I'll call for the vote. All those in favor say aye.
Aye.
All those against? Ayes have it. Motion passes. 17C, oil gas permit 1, permit 162 Warwick, Artemis Precinct 2, County Road 209, review and approve.
So I've been out to this location as well for this permit. I've already signed it for Warwick. And so I'm going to make a motion to approve permit 162 for Warwick.
Second.
Motion made by Commissioner King, second by Commissioner Moore. Do you have any other discussion regarding 17C1? Hearing none, I'll call for the vote. All those in favor say aye.
Aye.
All those against nay. Ayes have it. Motion passes. We move to agenda item number 18, Sheriff Jim Stewart, Sheriff's Office.
everyone.
Morning,
Okay, the month of June, had 1,967 calls for service. 580 of them were reportable, 1347 basically, there was not any action or anything found at the time. We had 63 livestock calls, month of June, 25 animal complaints, 21 mental health calls, and 2 burn downs. And that, let's see, security checks.
Sure.
Yes, burn ban,
And what was that?
in June, that was probably just
Was it
about
about
this.
Okay, all right.
Yeah, we haven't done anything since the expiration date, but we did have a couple, like almost right at the end of it. Let's see. Security checks, 213, patrol buys, 813, basically 10,026, 1,026, proactive, patrols. Traffic, code enforcement, 452 contacts. Resulting in 93 citations, traffic citations, 10 other citations. We wrote 1 burn ban citation, 1 animal complaint citation, no livestock citations, and 430 traffic warrants for the month. CID for the month closed 15 cases, had 98 new cases opened. 2 cases juvenile probation, 41 to the county attorney's office, 14 to the district attorney's office. Criminal interdiction OLS stats, 21 felony arrests for the month, 10 misdemeanor arrests, 225 traffic stops, assisted patrol on 6 occasions. It seized 1 weapon, 1 stolen vehicle, seized 1 vehicle out of the arrest, had 3 days out of county on task force operation, had none in the county this month, had 5 undocumented or illegal aliens turned over to border patrol. Stats, 1,165 grams of meth, 127 ounces of marijuana, THC oil, 10,240 ounces, heroin, 32.27 grams, MDMA, 5.38, cocaine, 165 grams. And we had 5.93, or some criminal showed up this year, we had 5.93 grams of that. For the jail for the month of June, we averaged 122 inmates, which is running a little bit, we had a little bit of a drop, been running over 130. We had 11 U.S. Marshal inmates for a total of $25,560. House 6 for Gonzales County for a total of $10,800. Courthouse security drove 10,380 miles in the month of June. They had 24 reportable calls, basically stuff they had to take reports of, and they were non-reportable. This includes the flex deputies, by the way. In-county transport 60, out-of-county transports 41. They did 3 mental health transports, and they arrested 8 folks, probably out of jail for court commitments. Any questions? Any questions? Sure. Thank you.
Sure. Agenda item number 19 is on that tax assessor collector, county tax assessor collector monthly report. She's not here, but we have the report in there if you want to take a look. Agenda item number 20 is Christina Moots, county treasurer, discuss state action on county treasurer financial.
Good morning. No, I'm going to do that. Holding your compassion out. Yeah.
So what you have in your binders today is the June 2025 report. As always, reports come state claims, so you'll see covered by the first page, technically the second one, listing all of our accounts. Within the month of June, of course, our debit and our credit, which leaves you with any balance. Then the CD, or you have at the bank. Then you'll see the following page, all of our investment accounts. Want to note that we're still at 4.4 interest. Finish growth, so stay there. Then roll it out. And then followed by our outstanding debt. Nothing changed for the month of June there. And then ending with what I would call is labeled our treasury month report, that you can look at each individual fund and show the beginning and any balance with any of the debits and credits that were done within that fund. Before moving on, because also I do have the investment report, quarterly report. Before I move on, there's any questions regarding the report for the month of June.
Do we know, looking at opioid settlement money we spend on, so we don't get much, what can it be spent on?
It's like you guys already voted to use it on something with the sheriff's office.
We did, but there's still,
That's $43,000.
there's still people.
The last thing that we used it on, it wasn't, fair renewals for us.
Yeah.
Okay.
We used it on was handheld renewals.
And I can double check and make sure the exact amount of it dollars.
Well, I mean, we're not, I mean, we get a few bucks now and again when they settle with each of these companies, but I mean,
Yeah, let me just go back and double check and see what.
At the last time I looked, I don't think that there, well, I don't want to speak out of turn on some research, but
yeah, I think
I think it was just deposited into the general fund, and then the last time that I did this research, if I remember correctly, I just brought it to the board of what we wanted to use the sheriff had to request the radius, whatever the purpose was, and we voted to fund for it, but I don't know that that's correlated.
Well, it's that or buying more cameras, because that's showing a deficit because of it being a grant. So is there $43,000 in the opioid settlement fund or not?
according to this,
Yes, because that's our second payment. We received our first payment and used that first payment. I think it was like 38,000 and some change for the purchase of what with the sheriff's department.
Yeah.
So we received the second payment and just deposited it into the account.
That is what your number right there. So we'll go back and I'll double check on how that answer will go. Yes, okay, if there's any questions, I will go on. So what you also have is the interest that has been earned for the quarter, April, May, and June, for all of our investments, but as well as our CDs and our checking accounts. Again, I do list the beginning, any debit, any withdrawals, should say credit and debit, but then as well as the interest earned. So you'll hit the very bottom, with ending on June 2025, this quarter, is $384,294.19. Again, that's the investment account we have, our CDs, as well as our checking account. For the month, there's 3 months. And I do work in interest, so you'll see,
We'll finish off on that. We'll let you know. If there's any questions regarding that report.
So you don't need a court approval on the quarterly investment report? You do or not? It's just that we don't fund for it?
No, no time for it. It's just an overview basically, so you've already approved those months, well, you're about to do June, but it's just an overview of the last 2 months.
I'll make a motion to approve the June 25 treasurer financial report.
Motion made by Commissioner Martin, seconded by Commissioner King. Is there any other discussion regarding agenda item number 20? Hearing none, call for the vote. All those in favor say aye. Aye. All those against nay. Ayes have it, motion passes. Thank you.
Thank you.
Agenda item number 21, Jalen Waterford, Human Resource Specialist, presentation of payroll and personnel changes.
Jerry Oakland was hired as a road hand for precinct 4, making $21 an hour or $43,680 annually effective tomorrow, July 29th. Jesus Moffitt resigned from his position as a courthouse security for the Sheriff's Department effective Friday, July 25th, and is now employed part-time with the County Attorney's Office effective today, July 28th. And Sean Hunter resigned from his position as road hand for precinct 2 effective July 24th.
Any questions? Thank you. Agenda item 22, this brings the Reno County Auditor to discuss the impact on county bills.
Total amount available is $345,848.27.
We're still looking over, Mr. Reno just got back from the Vatican. Did you pray for rain for Wilson County? Did you see the Pope and ask him to help us out?
I did actually.
All right.
I'll make the motion to approve the bills for $345,848.27.
Motion made by Commissioner Martin, seconded by Commissioner King. Any other discussion regarding agenda item 22? Hearing none, I'll call for the vote. All those in favor say aye.
Aye.
All those against, nay. Ayes have it, motion passes. We are going to stand in recess until 1 o'clock. We'll reconvene here for our budget workshop.
Yes.